Well, the Colorado legislature recently closed their current session, and during that session, they passed a number of bills which addressed aspects of rental housing in Colorado. I'm Marc Cunningham at Grace Property Management, and we're going to start a series where we go through a number of those bills and explain how they impact you as a renter or you as a housing provider in Colorado. So we're going to start with one of the most impactful bills, HB25-1240. Now, this bill has a lot of intricacies. This is not meant to be a comprehensive explanation of the bill, but we'll just go through some of the main points that you need to be aware of if you're a housing provider in Colorado. Now, one of the most impactful parts of this bill is it now requires all landlords in Colorado, regardless of the size, which is a difference from how it was previously, it requires you to accept Section 8 or subsidized housing. I'll explain that in a little bit more detail, but that's the major thrust of a big part of this bill. Now, the name of the bill is Protections for Tenants with Housing Subsidies. So they explain it. It's an 8-page bill, relatively short as compared to some of the other bills, but there's a lot packed into this bill. So some of the things that it does that you need to be aware of as a housing provider. Number one, and this is a big part of it, it requires the notice for an eviction to be delivered upon the tenant for non-payment of rent if they are subsidized in any form or fashion to be a 30-day demand notice. So if your tenant is Section 8 or they receive a government subsidy of their rent and they don't pay rent, you have to serve them with a 30-day demand notice before you can initiate any type of legal eviction process. That's a long period of time. It's a 30-day period of time, a full month. Now, this is part of the CARES Act. The CARES Act was passed federally during COVID. The CARES Act didn't technically expire because there was no expiration date within the CARES Act, but most states have said, well, that expired when the COVID aspect of things ended. Colorado did not. Colorado went actually a step further to codify and make that permanent. So meaning, if your tenant is a subsidized housing provider, or if they receive subsidies, you need to give them a 30-day demand notice. But it goes beyond that as well. Because even if they're not subsidized, if the property that you own has a federally backed mortgage, it is covered under this act. So if you have an FHA mortgage as an investor, you buy a house, there's an FHA mortgage on that, you place a tenant, the tenant is not subsidized, but you place a tenant, the tenant is delinquent with their rent, you have to give them a 30-day demand notice for the delinquency of their rent before you can initiate any type of a legal proceedings. Now, this can get very complicated because many landlords, they don't even know if their mortgage on the property is federally backed or not. But you need to find that out and ensure that you're providing the appropriate notice to the tenant. Some other things it does, it removes the exemptions for small landlords to not accept housing vouchers. So previously in Colorado, if you were a landlord with less than 3 or 5 rental properties, then you could decline to accept Section 8 or housing vouchers. So if an applicant called and said, I'm interested in renting your property, and I received Section 8 housing, if you were a small landlord, less than 3 or 5, you could say, I'm sorry, I refuse to work with that housing provider. We don't accept subsidies. You could say that. If you owned more than that, you couldn't say that. Well, now nobody can say it. It's across the board, because if you decline to accept source of income, or if you discriminate based upon source of income, that would be a fair housing violation. So all landlords in Colorado, regardless of whether you own 1 property or 1,000 properties, you're required by law now to accept the subsidy and all of the parts that come with that as well. Because another part of the bill specifically says that landlords are required to respond timely. They're required to cooperate with both tenants and the tenants' rental assistance agencies and in good faith. So you can't say, well, we accept housing, but be delayed in filling out the paperwork for the housing agency. You're required by law to operate in good faith. Now, what is good faith? That's always open to interpretation. But in essence, you can't delay that. If your applicant receives a housing subsidy of any kind, you must work with the subsidy program to try to get them through that process. Another aspect of this bill is if the tenant is subsidized, in the case that we're talking about, and if they don't pay rent on time, the maximum late fee you can charge is $20. So that's an important aspect per your lease agreement. You need to make sure you edit your lease agreements for that. If the landlord violates the warranty of habitability, so that this law kind of winds in some different directions. This is landlord habitability type things now. And the habitability laws that have passed in the last couple of years have gotten very complicated and very confusing. But if there's a violation by the landlord as it relates to habitability, there's two things. The landlord has to reduce the rental rate. They have to reprorate the rent. And it's kind of complicated and confusing, but it's based upon how much of the property is under construction for the habitability issue. If one shower stops working for a period of time and they have another shower, is that a 25% reduction in the property? So there's a lot of uncertainty around this, but it requires the rent to be proportionally reduced. And in addition to that, this new bill, HB 1240, requires that if the tenant had prepaid rent, some of that rent has to be refunded, it has to be prorated and refunded back to the tenant, even if the rent was originally paid by the housing provider. Now, if this all sounds confusing, it is. So this is just how we deal with these things. Now, this bill is in effect now. There's no wait period on this. So May 29th, it is in effect. It applies to all housing providers. One thing that the legislature has been doing with this new group of laws they've passed is they have had no carve-outs for small landlords. Historically in Colorado, there have been carve-outs as it related to housing laws for the small landlords that maybe just owned one rental property, no more. All these bills apply across the board to everybody, starting with HB 1240. Now, the violation fines for this bill are significant. They start at $5,000 plus civil penalties, and I think they cap out at $50,000 plus civil penalties. So these are not things to play with. You need to make sure you get them right. Now, we are not attorneys, although we've worked with our attorneys to understand these bills. These are our interpretations of them. We will link to the bill itself. Jump on our website, rentgrace.com. But if you're one of a landlord that works with us, don't worry, this is what we do for you. We ensure that you are fully compliant with these. If you're a Colorado housing provider and we can provide assistance, we're happy to help if we can.